Thank you so very much, Linda, and I hope you folks know how lucky you are and fortunate to have Linda here as a professor. I do not know a better historian in the country, or one whose work I admire more than Linda, and I have certainly enjoyed being here at your school, which I had known about, of course, through Linda. Linda mentioned there are seats in the front, of course. I want you to know that I, one time, with 750 students at the University of Illinois in the Assembly Hall, went to the back of the Assembly Hall and gave the lecture. After that, most people came to the front. It's a sort of a nerve-wracking thing to turn your necks. Well, even after all the ancient years I've been teaching, probably before your parents were born, I still get nervous before I do any lecture. And you can sort of take the boy out of the Southern Baptist denomination, but it's hard to take the Southern Baptist, I think, out of the boy. The University of Illinois, I was right proud. I worked myself up from a Baptist deacon all the way to a Presbyterian elder, and I swear if I'd have stayed those 2 more years to have maxed out my retirement, I think I'd have made Episcopalian. But before I did this lecture over at the Renaissance, I got out the Bible and pulled it out as I normally do before lectures, started reading. Just at the beginning of the Bible, the creation story, before I said a prayer, and notice that the creation story is different here for Rock Island than any place else I have ever seen the Bible. So it goes like this. God is creating the world, at which point Jesus says, "Mother, you have left out Rock Island." At which point God says, "We'll make it up to him. We'll give him this magnificent Mississippi River. We'll give him rolling hills and very close to the most fertile farmland in the world. We'll make sure they have big industry and opportunities, and we'll even give them a great university there and college." At which point God said, at which point Jesus said, "Don't you think you're overdoing it a little bit?" And then God said, "Well, not when they find out who their neighbors are." So I am one of those neighbors in the sense of 2 ways. That is, I spent 34 years at the University of Illinois. In fact, I taught Southern history at the University of Illinois, and I wrote this book, The Age of Lincoln. And even though I argued Lincoln is the greatest president, the greatest theologian of the 19th century, and even a Southerner, when I got back home to South Carolina, I discovered people down there do not like Lincoln very much. So I am 2 ways one of those people who keep you humble from South Carolina and down the road from Illinois. Well, 2 things changed the Voting Rights Act to change modern South: air conditioning and the Voting Rights Act. Am I echoing to you guys? Too loud? It's going to be hard with me. I'm used to not doing it with a mic, so let me know if I'm going up or down or whatever, okay? Sadly, Americans understand better how air conditioning operates than how the Voting Rights Act works. And I'm not making this up. I think that we believe in science. We think science is important. I really enjoyed the presentation that preceded mine about renewable energy and things. So I think people understand the investment of that, but not so much, in fact, understanding how important humanities, under social sciences, and particularly understanding our history, what we used to call civics, is. We sort of assume that we have democracy, but democracy is not static. It can advance and it can also retreat. We're going to look at some of that today. Now, the historians have begun to study the Voting Rights Act, now 50 years old, must give pause to those who understand this landmark civil rights achievement, because historians, like vultures, usually devote their attention to subjects no longer alive. Now, I recently presented on the Voting Rights Act at a congressional briefing, and even the invitation sort of hinted that, and I quote, that the briefing will reflect on the history and legacy of the Voting Rights Act. Words like legacy and history do not mean that we're talking about a problem of merely historical interest. Now, the Civil Rights Movement brought about this extraordinarily effective legislation, and the Voting Rights Act has brought and continues to bring electoral fairness. One more time, it sounds like to me I'm echoing up here. Is it still doing that? I think it's just I get loud. It's what I'm doing. Yeah. And I'm messing you up. And I don't know how to talk otherwise. Can you understand them? Okay, well, just live with me. Can you understand the accent? I want you to know that when I went to Princeton to graduate school, one of my two advisors was asked how I was doing because I was sort of an unusual for a student at Princeton. And he literally said, I have no idea, I can't understand a word he said. So the civil rights movement brought about this extraordinary effective legislation. The Voting Rights Act has brought and continues to bring electoral fairness. The success of the Voting Rights Act, though, has come with a price. With the Voting Rights Act, the civil rights movement moved from public protests in the streets to legal activism behind closed courtroom doors. Even as civil rights and voting rights attorneys won in courtrooms, the civil rights movement lost in the court of public opinion. Instead of well-publicized marches and speeches, many civil rights activists turned to the courts to accomplish their goals by the early 1970s. Because legal rulings are less enthralling than protests, we do not know our history and the full story of resistance to the Voting Rights Act of 1965. We've forgotten that the Voting Rights Act and litigation surrounding this important legislation protected and continues to protect African Americans and minority groups' right to a vote. The Voting Rights Act, which re-enfranchised many African Americans after 1965, has always depended for its impact on Supreme Court decisions, which have passed through repeated cycles of support and restriction and have recently severely undermined protections, leaving minority voting rights at the mercy of voter suppression laws passed by their partisan enemies. Our failure to appreciate the importance of the Voting Rights Act has led to court decisions which weaken this essential legislation and undermine essential American right, the right to cast a meaningful vote. Now, a long list of well-known martyrs died for the rights of African Americans to vote. Medgar Evers, Viola Liuzzo, James Chaney, Goodwin Swerner, and of course Martin Luther King Jr., and tragically so many more, especially African Americans whose story has never been told. And I want to put a plug in here if you're interested. In the spring term, you're going to have a course taught on African American history. And I think as we go through this, you see all the incredible things that are happening today and the historical suggestions and parallels. I would hope that many of you will sign up for it so they have to create 2 courses. You'll have so many in there. Well, more than 150 years ago, and a lot of people, I think, are unaware of this, Abraham Lincoln was murdered, not for the Emancipation Proclamation, but for advocating African American suffrage. On April 11, 1865, Lincoln gave his last speech. One man in the audience understood perfectly what Lincoln was speaking about. John Wilkes Booth told his companion, that means, and he used the N-word, citizenship. Now, by God, I'll put him through. This is the last speech he will ever make. Well, with the end of slavery after the Civil War, a whole century before the Voting Rights Act, the Civil Rights Act of 1866, 1870, 1871, there were 2 of them that year, and 1875 gave African Americans a right of equal accommodations and citizenship. The 15th Amendment to the Constitution, ratified in 1870, states, the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, and that Congress shall have power to enforce this article by appropriate legislation. Newly enfranchised men, it was only men, of course, the suffrage of women, the women vote comes later, could vote for and often elect candidates of their choice. African American voting during Reconstruction led to a black and white coalition of Republicans and an interracial democracy in the South. But white supremacists would not tolerate it, murdering elected black officials, stealing ballot boxes, completing whatever was necessary to stop the African American vote. White Democrats staged a violent and fraudulent coup d'etat and overthrew legitimately elected interracial Republican governments to end Reconstruction. The extremists, of course, I want to emphasize, were a minority of Southern whites. And I think the great failing is that people did nothing. They stood by, and the result was literally, was hard for us to imagine in America, a coup d'etat, an overthrow of a legitimate government. And this counter-revolution succeeded. Following Reconstructions, African Americans were totally disfranchised, And in 1896, in Plessy v. Ferguson, the Supreme Court ruled that separate but equal would be the law of the land, that is, segregation. And in 1901, in Williams v. Alabama, the court ruled states could pass disfranchising laws. The race to the bottom was owned in the American South, where a totalitarian society on race was basically created on the basis of white supremacy. White supremacists then voted out all the legislators, thinking they would never be elected again. More prophetic, however, was the 1901 farewell address by African-American Congressman George White from North Carolina. This is, Mr. Chairman, perhaps the Negro's temporary farewell to the American Congress, but let me say that Phoenix-like, he will rise up and come again. Because Brown v. Board in 1954 was a landmark desegregation case that overturned the 1896 Plessy v. Ferguson, historians have focused more on African Americans' campaigns to end segregation than their campaign for a fair vote. Yet I think that if you look at the historical record, if you take that course that I'm suggesting you do, you will discover that African Americans' central drive was for the vote. In fact, many of the leaders argued about segregation. Don't worry about segregation. If we have the vote, we can take care of segregation, including better schools and things like that. African Americans always emphasized the importance of the vote. W. Du Bois defined manhood in the United States as a right to the franchising system. We won't fool manhood suffrage, and we want it now, henceforth and forever. Castile Jackson, near my home, wrote to President Franklin Roosevelt regarding the proposed anti-lynching bill. It's not worth the paper it is written on. Rather, he implored that African Americans be given the right to vote so they could work out our own salvation state by state. Osceola McCain, who was an African American field organizer of the Southern Conference of Human Welfare, traveled throughout the South in 1946 and reported, "The Negro masses have a keen discernment of the relationship of voting to their everyday lives." Benjamin E. Mays, from my hometown, the longtime president of Morehouse College and the spiritual mentor of the civil rights movement, continuously avowed from the 1930s into the 1980s that the right to vote is the most sacred thing a man can have. In 1957, his student, Martin Luther King Jr., echoed his mentor when he equated the right to vote with America's sin of slavery. "So long as I do not firmly and irrevocably possess the right to vote, I do not possess myself," King demanded. "Give us the ballot." Well, the bloody events of the summer of 1963 in Birmingham, Alabama, and subsequent assassination of President John Kennedy caused Attorney General Robert Kennedy to fear revolution if some government action for civil rights were not taken to defuse the situation. Intended to eradicate racial discrimination in America, the 1964 Civil Rights Act merely reinstated provisions of the earlier Civil Rights Act of 1866 and 1865 and stressed voluntary compliance through state and local action. Despite formidable efforts of local African American leaders, civil rights organizations, voting education projects, minority voter registration was abysmal. Alabama still had less than a fifth of eligible African Americans registered to vote in 1965, which increased from only 14.2% to 19.4% in those 6 years. In Mississippi, where mythic SNCC leader Bob Moses valiantly struggled in 1960, black voter registration increased from 4.4% to only 6.4%. One study of the 1964 Mississippi Freedom Summer chronicled 6 murders, 35 shootings, 65 bombings, 80 beatings, and only 1,200 African Americans registered. Throughout the southern states, arbitrary applied literacy tests continue to disqualify African Americans from registering. That's why you have an emphasis on the voter education schools. One of the problems with literacy tests is in their application. And this is central today about how important the people at the local level are who allow people to vote or not. For example, a local Democratic committee executive spokesman wrote to a journalist in 1940, "There are damn few Negroes registered in any way," he observed. "If a coon wants to vote in the primary, we make him recite the Constitution backward as well as forward. Make him cross his I's and dot his T's, and we have to comply with the law, you see." In 1962, SNCC addressed some of the methods of voter suppression. Whatever the apparent procedure, purging or inflating of voting lists, economic warfare, police brutality, etc., all attempts to nullify the right to vote among Negroes have aimed at psychological enslavement, which has increased in effectiveness throughout the years. In 1965, the goal was straightforward: the right for African Americans to vote. Because the Civil Rights Act of 1964 had passed only after closure entered an 83-day marathon Southern filibuster, few believed that further civil rights legislation would be possible. Continued Southern violence, as well as a Democratic landslide in the 1964 presidential election, however, created a climate that allowed President Lyndon Johnson to address voting rights. Martin Luther King Jr. chose the ideal city to focus the fight for voting rights. Selma, Alabama was a bastion of white supremacy and the Ku Klux Klan. One cannot stress enough the importance of the media in the success of the civil rights movement, and especially the passing of the '65 Voting Rights Act. The importance of newspaper photographs and TV goes a long way to explaining the difference in why this so-called civil rights movement is known as the Second Reconstruction of the 20th century was successful, and the first Reconstruction in the mid-19th century ended so quickly. During the first Reconstruction, Northern whites just found it hard to believe that white Southern Democrats were actually that violent and that fraudulent. They fell subject to claims that black and white Republicans exaggerated the degree of terrorism and violence against them in the American South. 75 years later, in the 1960s, photographic documentation of the mayhem was broadcast daily into people's homes. On TV, Americans watched senseless white savagery, now infamous in the history of the Civil Rights Movement. Bloody Sunday on Edmunds Pettus Bridge on March 7, 1965, represented the white South's extreme opposition to black voting. Selma was directly responsible for passage of the Voting Rights Act. Even before King renewed the Selma March, President Johnson appeared before television before Congress to encourage strong legislation for racial justice. There can be no argument every American citizen must have an equal right to vote. Racial inequality barred the sacred heart of America and challenged the values and purposes and the meaning of our beloved nation. When in August 1965, Congress passed the Voting Rights Act, Nicholas Katzenbach, then Attorney General, remembered Lyndon Johnson's charge. He wanted, I won't use his language, he used God's name in vain, the GD toughest Voting Rights Act that you can devise. And here's one of my favorite pictures, of course, of Johnson signing the bill. A decade later, Katzenbach labeled the bill the most successful piece of civil rights legislation ever enacted. Reverend Theodore Hirschberg, then President of Notre Dame, he was chairman of the U.S. Civil Rights Commission, proclaimed the Voting Rights Act one of the most important legislative enactments of all time. Even in 1981, and leading up to an important 1982 renewal of the Voting Rights Act, conservative Republican presidential icon and native Illinois son Ronald Reagan promised, as long as I am in a position to uphold the Constitution, no barrier would ever come between a secret ballot and the citizen's right to cast one. Reagan reaffirmed that voting was the most sacred right of free men and women. He announced that for this nation to remain true to its principles, we cannot allow any American's vote to be denied, diluted, or defiled. The right to vote is the crown jewel of American liberties, and we will not see its luster diminished. He continued. The Voting Rights Act is important to the sense of trust many Americans place in their government's commitment to equal rights. Every American must know he or she can count on an equal chance and an equal vote. Now, Congress's purpose in enacting the Voting Rights of 1965 was to provide minority voters an equal opportunity to participate in the political process. The Voting Rights Act departed from precedent of Congress by providing for direct federal action to enable African Americans in the South to register and to vote. Made a huge difference in counties. To counter the actions of discriminatory local officials, the Act authorized the use of federal examiners to register persons in designated counties and federal observers to monitor the conduct of elections. The most novel feature of the Act and one of the most effective enforcement mechanisms was the pre-clearance requirement set forth in Section 5. Under its terms, all changes in voting practice in states covered by the Act's special provisions must be pre-approved by one of two fact finders, either a 3-judge panel in the federal courts of the District of Columbia or the Department of Justice. The Voting Rights Act of 1965 was challenged immediately and continues to be challenged to this day. In 1966, in South Carolina v. Katzenbach, plaintiffs claimed the act violated the state's right to control and implement elections. When South Carolina, first in nullification, first in succession, challenged the constitutionality of the Voting Rights Act, the states of Alabama, Georgia, Louisiana, Mississippi, and Virginia joined the suit. The Supreme Court, however, upheld the law in 1966. Chief Justice Earl Warren explained the new departure. Congress felt itself confronted by an insidious and pervasive evil. The Chief Justice noted the long history of racial discrimination in the voter registration process in South Carolina, directly quoting some of the most outrageous remarks of Pitchfork Ben Tillman at the 1895 Disfranchising Convention as evidence of the discriminatory purpose of the literacy test suspended by the Act. Warren stated that the constitutional propriety of the Voting Rights Act of 1965 must be judged with reference to the historical experience which it reflects. The Supreme Court dismissed the complaint. Hopefully, millions of non-white Americans will now be able to participate for the first time on an equal basis under the government under which they live. In that 1966 decision, the Supreme Court ruled that Section 5's pre-clearance requirement, like other challenge provisions of the Act, was constitutional. The Voting Rights Act was, according to the Warren Court, designed by Congress to banish the blight of racial discrimination in voting, which has infected the electoral process in parts of the country. The court acknowledged that whenever the Justice Department obtained favorable decision, striking down particular tests, Southern states enacted new discriminatory devices. I quote, Congress had reason to suppose that these states might try similar maneuvers in the future in order to evade the remedies for voting discrimination contained in the Act itself. And indeed, when African Americans managed to register and vote in significant numbers, Southern legislatures often adopted new electoral procedures designed to dilute minority voting stream. Use of at-large elections, that is, requiring candidates to run citywide or countywide rather than for smaller districts, was the cornerstone of vote dilution. Because racial minorities tend to be racially segregated, they often represent a majority of the prospective voters in election districts and thus have the potential for election candidates of their choice. Where elections are conducted at large, however, where whites are majority of the electorate and whites vote as a bloc against candidates preferred by minority voters, the candidate preferences of the minority community are submerged in the larger pool of white voters. So after the Supreme Court rejected the 1966 challenge, immediately Mississippi and Virginia filed cases which were decided in 1869 in Allen v. Board of Elections, contending again unsuccessfully that the Act protected only the right to cast a ballot, not the right to have non-discriminatory election structures such as district elections. In 1970, the Voting Rights Act was renewed, the formula updated for the covered county, and it was strengthened. And then in 1973, a unanimous Supreme Court in a legislative redistricting case from Texas, White v. Rester, struck down the use of multi-member districts to elect members of the State House of Representatives in 2 counties. The court's opinion relied on evidence of a history of official discrimination against African Americans in Dallas and Hispanics in Bexar. Based on what it called, quote, the totality of circumstances, the court found that minority voters in these 2 counties had, quote, less opportunity than in other residents to participate in the electoral process and to elect candidates of their choice. In 1975, the Voting Rights Act was renewed and again strengthened for a second time. Now, originally when Texas, and because Texas had no literacy test, and probably even more important, conspicuously, native Texan Lyndon Johnson was the president, it was not included under the original Section 5's pre-clearance laws. With the 1975 renewal, then Congressman Barbara Jordan directed efforts to include Texas. Jurisdictions that required English-only ballots were added in Section 201, and this expansion has made a huge difference in Hispanic, Native American, Asian, voting influence throughout the United States, not just in the South. Just 7 years after the favorable ruling in Texas, the White v. Rester I just mentioned, the Supreme Court struck a blow, really the first major one, against the Voting Rights Act. In 1980, the court ruled in the city of Mobile versus Bowling a challenge to that city's use of at-large elections. That plaintiffs must prove not only that an at-large system has a discriminatory effect, but it also was adopted or maintained for the purpose of diluting minority voting strength. Take note, not just discrimination, but it had to be purposeful discrimination. Thus, the courts hindered voting equality by welcomingly seemingly neutral, but actually discriminatory practices. In the meantime, voting rights attorneys needing help with the intent to reach out to historians who were trained to assess the motivation of lawmakers. And I started to give the whole talk just on that. That's when I got involved with voting rights, when civil rights attorneys knew that they needed historians to get involved to show this intent. In the view of many observers, the Mobile decision that plaintiffs had to show intent was inconsistent with the views of Congress when it adopted and expanded the Voting Rights Act. A substantial majority in both houses, and I want to emphasize a bipartisan majority, and for the first time, longtime opponents of voting rights of African Americans, leader of a filibuster, again and again, Senator Strom Thurmond, who was chair of the Judiciary Committee, actually voted for the first time for civil rights legislation in the 1982 renewal of the Voting Rights Act. That's sort of how popular and untouchable it has seemed to become. And Congress revised Section 2 of the Voting Rights Act to outlaw election measures which result in diluting minority voting strength without requiring proofs of discriminatory intent, thus negating what the Supreme Court had done. The 1982 change also showed the strength of Congress' conviction that states should not be free to use subterfuge to deny citizens the right to vote. And created a new statutory means of attacking minority vote dilution, Congress cited again the Texas case of totality of circumstances test as an evidentiary standard. Vote dilution cases previously decided under the 14th Amendment would henceforth be tried under the new statutory standard. Again, the methodology of history as a discipline prepares scholars to analyze and assess a totality of circumstances. Now, Section 2 of the Voting Rights Act was always applied nationally and did not really have to be renewed. As amended in 1982, it was, and I quote, a means of eradicating voting practices that minimize or cancel out the voting strength and political effectiveness of minority groups. Section 2 bans the use of tests that interfere with the right to vote, procedures that call an unequal burden for minority voters, or any other change that minimize or dilute minority voting strength. Although Section 2 set forth broad protections, it places a burden on minority plaintiffs to bring a lawsuit and prove discrimination. In practice, lawsuits under Section 2 of the Voting Rights Act are so expensive that citizens seldom have the money or the legal experience to pursue a claim unless they are backed and financed by some large law firm or some large organization like the ACLU, MALDAF, the NACP. Now, the federal government has standing and can bring a case anywhere, that is the Justice Department. In contrast, state or local government jurisdictions defending the suit can pull from tax money to mount a defense of its actions. Section 5, therefore, with its preclearance, was more effective than Section 2 as a means of protecting the equal opportunity to vote, at least in the covered jurisdiction. Initially, almost all of them in the South, and then it was expanded. And Section 5 was the least burdensome on the minority victims of voter discrimination. Now, most recent challenges have appeared before a Supreme Court closely divided, which has not been as receptive to protecting voting rights. Some justices, like many citizens, believe that our country has grown up and that racial discrimination and racial issues are a relic of a bygone age. Those justices who believe our society is a way to go in uprooting the effects of our racial past have been consistently outvoted by justices who believe the job is largely done. The law has not changed. It's not different, but how the court interprets the law is. What is changing, I think, is our knowledge and understanding of how our history influences our politics. Now, especially since 2000, there have been a series of Supreme Court cases that have not gone well at Supreme Court. And I am going to skip a couple of these. I know you hate to miss out on the names of court cases, but to try to get time for more discussion. I do want to mention Bartlett v. Strickland, which was the typical 5-4 Supreme Court decision that struck down a North Carolina redistricting plan. And to not go into the detail of it, there had been a district where, in fact, an African American had been elected for about 20 years, re-elected to Congress, but it was not a majority African American district. It had a 39% African American population, voting age the way they figured it, but he had been an incumbent, had served well, and it drew upon a more liberal voting area of whites. And this was challenged, though, because the one person, one vote rule, which when it had come in, said you had to have equal proportion things. You had to start splitting counties, but North Carolina state, the state has a rule that you can't split counties. And what this is, we'll come back to it, how important this is in a Section 2 case later. This meant that the state was free to ensure that no minority opportunity district, not a majority, but opportunity, could be drawn in the area. A Texas case, again in 2009, involved a tiny jurisdiction in Austin, Texas. And I think we will skip that too, but basically Judge Roberts gave a warning. They allowed always, and this is one of the reasons about section, always you could bail out. You could show that you had done no discrimination in 10 years, then you could bail out of coverage of pre-clearance. And that's what happened. They avoided looking at Section 5. People worried that with Section 5, that is pre-clearance, if you let the areas take care of it, it would be like the foxes guarding the hen house. Well, a Southern comedian, humorist, Stephen Colbert, who's also from South Carolina, facetiously recommended historians should rewrite history. You've heard about revisionism, right? He quipped that it would be great if we could rewrite the history of slavery so it never existed, since we have a back precedent now. Now, although done in humor, there are indications the Court of Public Opinion, as well as some judges and justices of the Supreme Court, agree with Colbert that we can rewrite history to make it better. Some Supreme Court justices forget about our shared past of racial discrimination. In 2009, President Barack Obama's hometown newspaper, the Chicago Tribune, asked, does the election of a black president mean racism is no longer a factor in American politics, and are civil rights laws outdated in the age of Obama? The Tribune contended that Obama's election heralds the emergence of a colorblind society in which special legal safeguards for minorities are no longer required. Well, constitutional challenges to Section 5 of the Voting Rights Act culminated in 2013 when a divided Supreme Court in Shelby County v. Holder decided the formula specified in Section 4, which determines the jurisdictions that are required to submit proposed election changes for pre-approval, is not valid. This ruling, as Lyndall in introduction explained, disables Section 5. The formula, which people call the trigger, determined which areas of the county had to apply for pre-clearance. So if you don't have any, there is no pre-clearance. Outlined in Section 4 of the Voting Rights Act, this formula really had been updated since '75, was based on a history of blatant voting discrimination. Although a huge amount of testimony and evidence presented to Congress showed the continuing need for Section 5 coverage, especially in the South, and although Congress renewed Section 5 and the trigger formula in Section 4 of the Voting Rights Act, the Supreme Court found the formula unconstitutional. This finding eviscerated the essential pre-clearance of electoral changes in covered districts and literally crippled the Voting Rights Act. Eerily echoing one of the early Missouri courts finding the notorious Dred Scott cases. Everybody know Dred Scott? But okay. This is 1852 and 1858. Judge Roberts stated his reasoning for Shelby: our country has changed. This was depressingly similar to a ruling in 1852 where a previous decision in Missouri had a pattern of ruling for freedom, but where new decisions would be ruling for slavery. And this is a quote from 1852. Times are not now as they were. Now, while Roberts acknowledged that any racial discrimination in voting is too much, he considered it more important that Congress consider current conditions. Unlike the Warren Court, which upheld the Constitution's equal protection of individuals against racial discrimination as one of the principal duties of the U.S. Supreme Court, the Roberts Court argued that the court's role is more to protect the rights of the states to deal with voting as they wish. The Roberts Court felt that the problem of racial discrimination in elections was comfortably in the past, and the Voting Rights Act must reflect this new historical viewpoint. Yet today we see the continued existence of racially polarized voting and the Southern strategy of politicking with issues of race expanded nationwide. A recent survey finds that since 2010, 21 states have passed new voting restrictions. We see the reality of continued obstacles to racial equality, the Black Lives Matter movement, social media campaigns, as well as the post-Ferguson events across the country, including the tragic murder of 9 American worshipers in Mother Emanuel AME Church in Charleston, South Carolina. All this, I think, demonstrates the distortion of a post-racial society picture that was painted by the court. Historical context still matters, both in the immediate context of a bill's passage and perhaps even more important, in the context of the long degree of change over time. In the immediate historical context of increasing larger minority populations, Texas is now a majority minority state. The election of the first minority president, policymakers have to look carefully at how a particular law fits into the larger historical context of voting laws and other relevant legislation over the years. Historically, the dominant party has targeted groups of voters to prevent them from exercising their rights to vote or to minimize the influence of those votes. And this was a question that came to me when I was testifying in Texas, and I tried to explain. It's not partisan. It doesn't matter whether it's Democrats, Republicans, or Martians who are in power. They have always used that power, in fact, to disadvantage one particular group. Not all of them, but certainly African Americans every time. Something that has to be explained to courts is that suffrage has always been inextricably intertwined with partisan advantage, no matter which party. The justification for restricting the vote today is the same rationale offered by officials for disenfranchising voters in the 19th and 20th century. Their abuses included poll taxes and literacy provisions. Today's abuses include voter ID legislation, restrictions on early voting, and a lot of other measures. The stated justification, just as in 1964, is voter fraud. And I argue that's a pretense because in-person voting fraud has not been proven. And that's different than absentee ballot, but there's just been no evidence. In the oral arguments for Shelby County, Judge Antonio Scalia used the lofty status of the Voting Rights Act against it. Scalia mocked the large bipartisan majorities that passed the legislation and claimed that congressmen would not vote against renewing the Voting Rights Act because they were afraid of losing re-election. Really an injudicious charge having nothing to do with evidence before the courts, and an interesting interpretation, I think, of democracy at work. Scalia said about Congress' renewal of the Voting Rights Act, I think is very likely attributable to a phenomenon that is called perpetuation of racial entitlement. Whenever society adopts racial entitlements, it's very difficult to get them out through the normal political process. Scalia felt that the voting right was not an issue to be left to Congress. That's a concern that those of us who have some question about this statute have. That's Scalia. The majority opinion neglected to mention that huge mass of evidence that Congress considered that I mentioned earlier regarding the continual pattern of racial discrimination affecting votings in those very covered districts. The dissenting justice had an entirely different view. According to Justice Ruth Bader Ginsburg, quote, the court appears to believe that the Voting Rights Act assessed and eliminated specific devices extant in 1965 means that pre-clearance is no longer needed. With that belief, and the argument derived from it, history repeats itself. In a memorable metaphor, Ginsburg compared throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes to throwing away your umbrella in a rainstorm because you're not getting wet. This metaphor would prove to be tragically on point. Not long after the decision in Shelby County was announced, a storm of efforts to disfranchise minority voters rained down upon states previously subject to pre-clearance. For example, mere hours after the decision, officials in Texas put in motion a voter identification law that a federal court had previously refused to pre-clear because it made it more difficult for minority voters in Texas to participate in the political process on an equal basis with whites. When I was testifying in this case, and I was given the whole history of the poll tax, the literacy, and all of these, one of the questions the Attorney General from Texas had me say, well, Professor Burton, you cannot though name anything recently that the state of Texas has done like that. And I said, I can give you county after county of things, but not the state. And I said, no, but since 1976, when it was covered by the voter, it was stopped by pre-clearance, and then the very law that was just passed, and I was in court for the voter ID, was stopped by the courts again, and the minute, literally the minute, the Voting Rights Act, Section 5, was determined ineffective, you did put it back in. So that I would argue the reason you had not had those disfranchising laws because the Voting Rights Act was in place over time. There's an unfortunate pattern. The Bartlett case that I mentioned in North Carolina in 2009 makes it much more difficult to win a voting rights case under Section 2, and the Shelby case, 2013, leaves areas protected under Section 5 without any protection other than now a weakened Section 2. In the aftermath of the Shelby County decision by the Supreme Court, minority plaintiffs and the Department of Justice seek to use Section 3 of the Voting Rights Act to persuade courts to find the section. Unfortunately, you have to also show intent, again, to implement this other pre-coverage, and we've already talked about how difficult intent has been. Proven intent has never been easy, and it's more difficult than ever because the politician of our day is not as careless in talking about their racial purposes as were Southern politicians of the early era. Moreover, even when intent has been proved, even when there is smoking gun evidence of discriminatory purposes, some judges are still reluctant to rule on intent. Justice Scalia felt that voting rights was not an issue to be left to Congress. He articulated that concern of the Voting Rights Act, I quote, a concern that this is not the kind of question you can leave to Congress. And yet Congress must and does continue to act. When the courts ruled against sections of the Voting Rights Act, Congress in bipartisan amendments and legislation strengthened and reinforced the act. Congress revised the Voting Rights Act in 1982 to set up a statutory standard of results and effect without having to prove intent. In 2006, when the Voting Rights Act was renewed for another 25 years, support for Voting Rights Act was overwhelming. In the House, 390 to 33, and in the Senate, it was unanimous, 98 to nothing. I think it's time for Congress once again to answer the Supreme Court ruling about intent and against pre-clearance. Well, in conclusion, someone told me to always say that to give hope to the audience. The Voting Rights Act has been a success story. It's designed to increase minority representation. It's done so. It's also reduced violence, increased responsiveness, provision of services to minorities, made political resources of African American and other minority communities more available to society as a whole, made it possible for Southern salons to support civil rights, made racial politics unfashionable, opened opportunities for minorities to pursue careers in politics. The voting rights has not increased racial polarization. If those of you who see polarization as a result of the Voting Rights Act, just imagine what it would have been if you didn't have the Voting Rights Act. But as the recent Supreme Court has illustrated, continued success is not inevitable. It was more than a quarter of a century ago that the eminent historian C. Van Woodward, who had actually been the expert witness in the 1954 Brown case and who testified in the 1882 renewal of the Voting Rights case, warned that revolutions do reverse. In the quarter century following 1865, we saw all of these things wiped out. In the second Reconstruction, of whom many believe the Voting Rights Act is a culmination, Woodward found similar reversals even in 1989. Since Woodward's warning, we can add to it the discouragement, a school-to-jail pipeline for African-American men, deteriorating relationships between police and the African-American community. On voting issues, we see not just the dilution method, but a return to disfranchising voters. And the American South is just before the 1965 voting rights, largely a solid one political party region where Democrats cannot easily win statewide elections, just as Republicans could before that. African-American voting strength has not really altered the reality of white dominance of Southern politics. Martin Luther King Jr. and African Americans understood that the right to vote is a moral issue. When the majority of Americans come to agree, the Voting Rights Act law passed. The issues of representation that currently surround the Voting Rights Act are complicated and technical. It boils down, though, to should minorities in America have the opportunity, or at least the equality of opportunity of voting? The Voting Rights of 1965 just accomplished for the second Reconstruction what those 1867 Reconstruction Acts did for the first, only because the legislation of the first Reconstruction had been negated was it necessary to pass the Voting Rights Act of 1965. With the end of Reconstruction of the 19th century to the 20th, the courts reversed the increasingly democratic tide. Courts today turning back the gains of the Voting Rights Act are doing the same thing again. U.S. tradition presupposes open opportunity for all, no taxation without representation. This battle cry demands that every citizen have political equality. This one. The principle of political equality for all, however, has never been fully realized. And I'm going to stop there. We have time to go through the cartoons.
You got 10 minutes for questions or whatever.
All right, very quickly to get you going on these. Sorry about this timing, folks. What is this? What do you think this is? Yeah, that's very good. You know, most people say a grasshopper, but it is a cricket. In fact, it's what we call good brim bait down in South Carolina. But when I went to Taiwan, I was amazed because it is treated and sold in pet stores like a pet, a cat or a dog. When I went to Thailand, it is a delicacy. The point is, you see the same thing, but it means different things to different people. And that's part of why I'm encouraging you to take this African American history course as well. Calvin was one of my favorite cartoons. I used to do a little lecture on the theology of Calvin. Can you read the cartoon in the back? So you see, you know, he's praising, and then the teacher says, who else didn't do their homework? There's no hint of that, of course, for Calvin. But it's the context that matters. This is how you get at motivation, how historians get at motivation. I think it's very important, understanding the context. And that's what I'm trying to do about the voting rights. Why does it matter? How does it go into context? This last was a little personal. You see the old man and what he thinks she's saying and what she was really saying. I think it's very, very important that we understand people do have different perspectives. And certainly I think that's true because of our history of Africa. One of the things I point out to people, there are folks still, African Americans, who go to vote today that have memories that they may be killed if they had gone into that courtroom to try to vote before. History matters. It's important to place these things in context. And it's important, I think, for the courts and Congress to understand that historical context of voting in America. Why am I not? There we go. Okay, I hope we have some questions. I would much rather have done questions instead of the lecture, but I hope it was useful. I hope I made somebody mad enough to ask a question. Yes, please. Oh, the two of you. Okay, go ahead. First, and then we'll move to the back of the first.
Ken, you mentioned this Section 2 versus Section 5.
Yes.
Martin's delivering challenges under Section 2.
Yeah, and that's nationwide. That's right, but it is so hard and much hard. And what that means, a case has to be found is after the fact. What preclearance did was it had to go through preclearance before it could go into effect. So the case I just testified in on the photo ID was a Section 2 case brought by it's so expensive, you cannot believe how much all of this cost. Expert witness flying them down, you know, all this kind of stuff that just court records are incredible. It's such that, in fact, most plaintiffs, and think about where people are all over the United States in little communities that these kind of things are happening to. And they just a floodgate opened up the minute Section 5 went back. It's sad. And most people don't understand. Section 2 never has to be renewed, although they're trying to gut it. That's what I was trying to say, and make it less and less effective. It was always nationwide, though most of the cases were brought in the South for obvious reasons. And a lot of people think the Voting Rights Act was initially just for African Americans with that special history. And I actually think some of the problems that people are having with it now has expanded to other minority groups, because how do you find what is a minority and other? Those are sort of theoretical or philosophical questions, and I will leave Lyndall to tell you about philosophy. Told me yesterday. Good to see you again.
Likewise. I was going to say, ask you, I'm just curious, has there been a decrease in black conservatism since, changes to the Voting Rights Act?
I don't know. I really don't know how to answer a really good question. There are obviously a number of black conservatives. I mean, Judge Thomas is a leading conservative. You have a number of essayists who are journalists who are leading conservative thinkers and academics. So I don't know. What's interesting, did I explain racial bloc voting? See, it wouldn't even matter if you didn't have what's called racial bloc voting. But I've done a lot of this analysis before. It's partly, I got involved because of intent, but I happen to be able to do statistics. And since NACP and these little law firms can't afford to pay people, they have very little money, I could also do the statistics for them. And what you discovered, even today, it's actually increased. Whites in general will vote for whites, and African Americans particularly, not so much as Hispanics, so it's enough there to matter. African Americans vote overwhelmingly for African Americans. So you have the racial bloc voting. If you didn't have that, you wouldn't need so many special safeguards, and that was the issue in Mobile. You had a large percentage of African Americans, about 42%. But as long as you had an at-large election, you know, African Americans still allowed to vote, it's just they can never elect anybody, to have anybody at the table when those decisions are made. And I like to distinguish, a lot of people do not, but I think it's a mistake because at local levels, like a little town like I grew up in, 96, South Carolina, school boards, at the local level, it's not really so much partisan. What really has happened in the redistricting process, and I hinted at that, the Voting Rights Act has been used as a tool by both Democrats and Republicans to use their excuse to carve out safe districts and things, and it's just a mess. I hope there'll be some way out of that, and I think it's got a lot of negative reaction to the Voting Rights Act, because how many of you wonder why it even matters about photo voter ID? I've done a lot on this. I meet a lot of legislators and things that they just don't. Well, everybody has a driver's license, right? Well, you can show statistically that's just not true. We do. You're in college, but you look at it, and in fact, one group surprisingly are old people who give them up. But another group is all of these poor people who don't, which makes it significant. And they say, well, it's free. You can go get a free thing. But taking off of work, it works just like a poll tax. I actually did this in Texas, showed that the amount of money it costs to get off work in certain counties, to take the bus, the amount of time over there, when they're open to get that done, worked out to be about the same amount as what a poll tax was in 1940. Which was used. So I said it's very similar to a poll tax. This is why, again, I emphasize history is so important. For that matter, social sciences, understanding these things can go on and on. But it's not that people believe, well, everybody's got a driver's license. But they don't. And for some people, it's difficult to get one.
Vernon, we got time for one more question.
Yes, please.
Could you just explain, like, pre-clearance a little more? Like, what exactly does that entail?
What was that?
Pre-clearance?
Pre-clearance was under Section 5, a jurisdiction, you know, whether it's a school board, county, or state, when you pass a law, and you were part of those covered states, originally they were all Southern, now there's a lot where they're Hispanic populations and things, had to send in that plan. And this was, in fact, like you're going to move a precinct voting place, even something that small. A lot of times they didn't do it, but they were supposed to. How that would then affect minority voters. And if it violated, made it harder for African Americans to vote, then it could not be pre-cleared. That's the simplest way to understand it. I think I used the term retrogression too, as sort of a technical term. I probably should have defined it. And it's basically, it can't get worse. If you were electing, if under the plan to elect people in 1980, one black was elected, you can't draw a district where no blacks are elected. But then that was one of the cases I actually left out to give you time. They ruled in 2000, in fact, that, so there are a lot of places where no blacks are elected, so there's no retrogression if you keep from electing, even though they have enough people to form a district and elect somebody, and that was a big blow then to Section 5 as well. But as long as you can, you know, have districts or areas where people are electing a minority at the same number. You're not under retrogress. You can imagine how people play with statistics. But one of the biggest things that happened, Lyndall gives me a hard time because I can't even get my PowerPoint to work, working with computers and thing, is when I started this, the only people, as an expert, who had access to be able to do the mapping were people like at the university, a large university with computers, or the federal government. It's very expensive. Now, these laptops, they have software that everybody can figure out. If they sit down with the numbers, you can literally figure out if I move one voter from this precinct to that precinct, I'm going to be able to elect this person over that person. So technology has also increased the way I think that the Voting Rights Act has been misused, but then people have just gotten more and more partisan because the technology's gotten so strong that you can get, back in, I think, 1980, you could only get the kind of level of data that you could do that with in large cities of a certain size. But now, even in rural areas where there's a lot of this goes on, you're able to do that.
Vernon, thank you for bringing your knowledge and experience and your passion to this.
Sorry we didn't have time for questions. I'd have rather had questions, but you can
We'll
get
hang
from
around
Lyndall,
here.
I'll stay here, and also you can email me. And I do respond to email, though I'm slow.
Please join me in thanking Dr.